Okay, welcome back to our YouTube channel where we talk about and give you lectures on courses of the Nigerian Law School. So today we're going to be talking about the power of attorney. We're going to be breaking it down in its simplest form. So whilst receiving this lecture, you really don't have to be in the library. You don't have to stress yourself. You can just be on your bed, relax, listen to the lecture, and learn relevant points that you will need for your bar finals. So now let's go. The power of attorney is a formal instrument by which one person empowers another to act for him. Take note of that word, to act for him. That is to say, someone is giving another person the power to act on his behalf or act in his stead for certain purposes. Now, the person given the power generally is called the donor. So take note of that for the purpose of your MCQ. So the person giving the power in the power of attorney is the donor, whilst the person to whom the power is given is the donee. So when you are asked the person giving the power in the power of attorney, what is it called? The donor. The person receiving the power, the recipient, is called the donee. Only a legal person, a person in law, that is to say, someone that can be sued and someone that can sue can be an attorney. So you cannot give power of attorney to a non-existent entity, all right, or an unregistered corporation or organization, because it is not a person in law. So what this means basically is that you can give your power of attorney to either a legal person or an artificial person. Now, the next point is for us to know when a power of attorney may be required. So a power of attorney may be required when the donor is unavailable. So let's say someone has a property here in Nigeria, and it happens a lot, but the person has traveled abroad, maybe just to relocate with his family. But of course, the property remains here, he can't take it out, so he may need to deal with the property one way or the other. But hence, he's not physically here in Nigeria, he will need someone to stand in his place. For that person to be able to deal with the property as if he is the owner who is now abroad will need to donate the powers to that individual. And the only way he can donate the power is through the power of attorney. So one of the instances where a power of attorney will be required is where the donor is unavailable. Secondly, where expert skills of the donee is required. So let's say the donee has expertise in dealing with real property or expertise in dealing with anything at all, but the donor doesn't have that expertise. So he can as well give the power of attorney to the donee who has the expertise to act on his behalf. Thirdly, where title is not transferred, but the donor wants the donee to deal with the land. So let's say you don't want to assign your legal interest in a property, but you want to give another person the right to deal with the property as if he is you. But of course, that legal interest still resides with you. So you can do that by a power of attorney. Where the donee to execute other instruments, of course, where the donee is expected to execute other instruments, you can just give him a power of attorney to enable him do that. Fifth instance where power of attorney may be required, where the donee simply relies on it as the final instrument of conveyance. All right. So of course you have conveyed already using the relevant documents, the deed, and all of that. But just to give more comfort, you can issue a power of attorney to secure interest of a purchaser pending the perfection of title of purchase or performance. Then it may also be required where a mortgage is by sub-demise. Now, if you look at the case of Chime and Chime, it tells you virtually everything you need to know about the power of attorney. And that is a 2001 case. It was reported in the 3 Weekly Law Report, Part 701. So if you look at page 527, you see the Chime and Chime. So what are the features of a power of attorney? 1. A power of attorney is an instrument of delegation. It is an instrument of delegation. So if you want to delegate to someone, you can do that by issuing a power of attorney. 2, it does not transfer interest in land. Now you must take note of this. And the case of Ude and Unwara is very relevant here. It's the case on point. So a power of attorney does not transfer interest in land. It could, however, be a means by which a transfer could be effected. Now, what that means is the way you use a power of attorney is basically not a good root of title. Unlike the deed of assignment, you can't use a power of attorney to transfer legal interest in land. Thirdly, it is useful when you want to execute. It is usually executed by one party, but it is not invalid if the donor and the donee execute it. Now, when we talked about deeds in one of the lectures, if you check below, you will see that the discussion and the teachings on deeds. We said a power of attorney is a deed poll. What that means is it's generally executed by one person, that is the donor. But of course, if both persons, the donor and the donee, execute it, that on its own does not invalidate a power of attorney. Now, when a power of attorney is under seal, we even talked about that when we're talking about deeds. If you want to give someone else the power to execute a deed, then the power of attorney that you intend to use in giving that person that power must be by deed. If you don't understand, just drop your questions in the comments section. All right. Now, sometimes a deed of a power of attorney can be irrevocable. A power of attorney is expressed to be irrevocable if it is given for valuable consideration and is expressed to be irrevocable. So it is clearly on the face of it expressed to be irrevocable and it is given for valuable consideration. So for example, the donor says, I give you a power of attorney over my property, and of course you have to specify what you are actually giving the person. The power of attorney to manage my property on the consideration of 1 million naira being furnished to me. So the donee pays you 1 million naira, and for that you give him the power of attorney to manage your property over a period of time. And you also have to state in the power of attorney that it is irrevocable, having the donee having furnished valuable consideration. Secondly, a power of attorney is irrevocable if it is stated to be irrevocable for a period of time not more than 12 months, whether or not given for valuable consideration. So if there's no consideration furnished, it can be irrevocable, but for a period not more than 12 months. If consideration is furnished, now take note of this. If consideration is furnished, the time limit of 12 months becomes inapplicable. But if consideration is not furnished, it can be irrevocable, but for a period not more than 12 months. All right. Now, under these situations, and by situation I mean under the instances where a power of attorney is irrevocable, the power exercised by the donee, that is the person that the power has been donated to, is not vitiated, irrespective of the death, lunacy, insanity, bankruptcy of the donor, until the consideration is realized or the time expires. Now, when you issue a power of attorney, remember it is an instrument of delegation, right? An instrument of delegation. That means the person who donates the power can revoke it and get back the power. Or better still, let me put it this way. The fact that a power of attorney has been issued does not preclude the owner of that property from dealing with that property. I believe you get that. And it's very clear. So there are instances where a power of attorney there are methods or modes of revoking a power of attorney. If I give you my instructions, or I delegate to you the power to do certain things with my property, I should be able to take back that power. So a power of attorney may be revoked: 1, expressly; 2, impliedly; 3, by operation of law. A power of attorney may be revoked either by 1, expressly; 2, impliedly; 3, by operation of law. Now, talking about the execution of execution by the attorney. So if I have given you power or delegated my powers to you via a power of attorney, and as an attorney you now want to execute documents, do you execute it in your name as attorney, or you execute it in the name of the donor? Now, the attorney should execute the deed in the name of the donor. That's the general rule. So you're saying, I, AXYZ, lawful attorney for such and such. But the attorney may execute in his own name, except where any statute directs that the deed is to be executed in the name of the donor. So you look at section 9 sub 5 and section 14 of the PCL, Property and Conveyancing Law, which is applicable to the Old Western region and the Old Midwestern region. Now, attestation. By now, you should understand what attestation means. And of course, we still have to go back to it when we start doing the draft. To be presumed validly executed, the deed creating the power, if executed out of Nigeria, must be witnessed by either a power of attorney, by either a notary public or a judge or a magistrate. So what that means is, if power of attorney is granted, right? If it is granted and executed outside Nigeria, that execution must be it must be notarized. If you can't find a notary public there, look for a judge or a magistrate. That is by virtue of section 150 of the Evidence Act. And that is because the act of a notary public is worldwide accredited or presumed to be regular. Now, looking at stamping and registration, a power of attorney attracts a fixed stamp of 50 naira. And I'm not sure that has changed. It is registrable under the Land Instrument Law of Lagos State. And of course, you need to look at other the laws in other states to know whether it's also a registrable instrument. It is the land registration law of each state that determines whether a document is a registrable instrument. Now, looking at the consent of power of attorney in Lagos State, for example, this is specifically to Lagos State, a power of attorney relating to sublease of state lands or certificate of occupancy must have the consent of the governor. So look at section 5 of the Lagos State land law. All right. Now let's look at the drafting of a power of attorney. Right. So you can now say, in case you want to draft it in your exam, so you can say the commencement clause. You can say, by this power of attorney given on this day, or this dash day of dash 2022, if it's in the year 2022, or you may not even put 2022, you can just say on this dash day of dash 20 or whatever. All right. Now, a power of attorney takes effect from the date stated on it. So if so when you date it, the power of attorney becomes effective. So you have to put your date there. It becomes effective on the date stated on it. So from that date, the donee can start exercising that power. And when you are making a recital, maybe let's say, for example, a deed of assignment is to be executed, and you are trying to trace how the attorney got his power, you refer to the power of attorney and cite the date. That clearly states that the power of attorney, the attorney got his power to deal with that property on a particular date. The power of attorney may also have a recital. It is rare, but it may also have a recital. Just to give a background, and I told you in the previous class on deeds, A recital can be narrative or introductory. Then there's also the appointment clause. So we have the commencement clause, the date clause, the dates, the commencement, the recital, then the appointment clause. So you can say I, XYZ of here dash hereby appoint XYZF of dash as my lawful attorney, so you can say as my lawful, true and lawful attorney, to in my name and on my behalf do all of the following. And you must understand that the power of attorney is construed strictly. So you must list specifically the powers you have given to the particular person. Power to sell, power to collect rent, power to give out property, power to renovate, power to do this. So it must be specifically stated what you are given. Now, also the testimonium, all right? The testimonium, you can say in witness whereof I XYZ have hereunto set my hand and seal the dash day of dash 20 first above written, or the day and year first above written. That's a testimonium. And again, at the end of the authority clause, the authority clause is where you state the powers you are giving to the person, right? You list them out. At the end, you can also say, and to do all things necessary and incidental to the matters above as I may lawfully do, so that someone will not wake up tomorrow and say the actions of your attorney has gone beyond what you have asked him to do. So this omnibus clause, the general clause, covers for that. Then, like I said, the testimonium in witness whereof I XYZ have hereunto set my hand and seal the day and year first above written. Attestation, signed, sealed, and delivered by the above named blah 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 in the presence of, although attestation is not a strict requirement of a power of attorney, it is necessary that a power of attorney be attested to by a notary public, judge, or magistrate for the presumption of due execution, particularly the one done outside of the country. All right. So these are issues or things you really need to know and understand in a power of attorney. A power of attorney can be invalidated if fraud or duress or undue influence is established. So those are ways you vitiate a power of attorney. So if you can prove that I never issued this, or I was deceived into issuing this, it can be vitiated just for that. The power of attorney the donee of a power of attorney cannot sue in his own name, but must sue in the name of his principal. So these and more will bring to you in subsequent presentations. Thank you very much. Please subscribe.